appear that issue, but you can also appeal a conviction on state constitutional grounds, all right? And so the state Supreme Court becomes the final authority on that particular issue, all right? So that's your last on a state constitutional issue. The U.S. Supreme Court obviously is the final issue on federal constitutional issues in federal cases. I do want to talk a little bit about the United States Supreme Court because it plays such a pivotal role in everything we've talked about this semester, and the decisions that they make are so impactful. So fact number one about the Supreme Court is it is the only court that is federally mandated in the Constitution. Every other court that exists in the federal system has been created by legislation, by the executive branch. So the only federal court that is specifically mandated in the U.S. Constitution is the United States Supreme Court. There's been a lot of discussion of this particular issue, but there are 9 justices that are Supreme Court justices. There's been some pressure, or at least some discussion about whether or not that number should increase. I don't think it would ever happen, or at least not in our lifetimes, but it could. And so, to win a case, or to be in the majority of a case, it's just a majority decision. So you have to convince 5 of the 9 justices for your side of the particular issue, and they essentially win the case.
I think that's what they were referring to as the Council of 9.
This is the current 9. Anybody name all 9? Go ahead.
Sonia Sotomayor, Clarence Thomas, Neil Gorsuch, Roberts, Brett Kavanaugh,
Nice.
Sam Alito, Sanjay Brown Jackson.
Yeah.
See how they have a red background.
Very impressive, right? That's 9. Those are the more sort of diverse, sort of representative Supreme Court in history. And once you're appointed and confirmed as a Supreme Court justice, it's a lifetime commitment. So you'll sit on the court until you die. Many Supreme Court justices have done. Die as essentially in office, or you retire, which they do as well. The significance of the Supreme Court this particular slide shows the different ideology, right? And so if we go back to this slide this way, all right? Judges come onto the bench with different viewpoints. We talked about Kirkpatrick's crime control due process model, right? Due process leans to the left, leans democratic, all right? More concerned about individual rights versus community safety. Crime control is more conservative, right? More Republican. More concerned about public safety over individual rights. We talked about how much of criminal justice is trying to balance those 2 issues. You know, how do we keep community safe, but not risk people's individual rights? And some people believe that they side towards a due process sort of view, that they are more likely to side towards individual rights, and other people side towards more community safety as issues. Judges are the same way in this particular issue. And so if you're a left-leaning judge, a due process-leaning judge, like Sotomayor, Jackson, and Kagan, right, you tend to view individual rights the cases through an individual rights lens, much more so than the other justices that are more right-leaning, crime control-leaning justices, all in the middle. And some, particularly Alito and Clarence Thomas, are particularly far to extreme conservative positions, whereas Justice Roberts, Gorsuch, and Kavanaugh tend to be more towards the center. also like right leaning, right? And so you can see how this impacts the court, right? 6 out of 9 justices are more crime control focused, and thus they tend to group in their decision making. There's exceptions to that, of course, but in general, it impacts the nature of law because they come to at it all from the same perspective.
In your opinion, do you think the justices should just follow the tooth and the letter of the law?
In my opinion, that's really difficult to do, right? Because when following the letter of the law, as we've seen with cases, figuring out how facts fit into the law, there's just not really, oftentimes, there's such gray areas. Black and white's easy in terms of on the legal side of things, but coming to some decisions about gray issues, which we'll talk about, because the letter of the law sometimes I think can be wrong, and judges trying to figure out wrong in the sense of not legally wrong, but morally wrong. And so judges respond to that. But you can see the power of this, right? Supreme Court justices are appointed by the President of the United States, confirmed by the Senate, right? And then they serve for life. And so if you're a judge if you're a president and during your 4-year tenure, justices retire or justices die in office, it gives you an opportunity to shape the court. This is President Nixon in the 1970s, all right, had the opportunity to appoint in 4 different Supreme Court justices. Of course he's going to appoint and look for justices that reflect his own political values in some ways. And thus he was able to shape the court pretty much from the 1970s through the late 1990s. The 4 justices, this is Chief Justice Warren Burger, Harry Blackmun, William Rehnquist, and Lewis Powell. All right. Again, I'm not going to try to put this particular slide up. I'm sure it won't show the other one. But this is former President Trump from 2000. He also had an opportunity to significantly reshape the court. He had 3 Supreme Court appointments that were confirmed that all, again, changed the direction of the court. He, of course, appointed 3 more conservative justices, fit more with his political perspective, and thus a Supreme Court that was leaning to the left, or pretty much 5-4, became much more of a right-leaning judge. And you can see how that has impacted some of the laws and some of the law changes that have occurred since those appointments. Because, again, you have 6 judges that lean towards a crime control perspective, and 3 justices that are more due process. All right. So a couple other facts besides 9. So one thing first to know about 9, in terms of the win a decision, all right? To win a decision, the 5 out of 4, right? So you have to have a majority in order to win a particular Supreme Court decision. To hear a court case in the Supreme Court, you only have to convince 4 of the justices to actually want to hear the case. And so, again, thousands and thousands of applications to hear the case, of the thousands and thousands of cases, only 4 justices have to say, this is the case worth hearing. They will then have oral arguments about that case, and then the Supreme Court will issue a decision based on that. The Supreme Court does have both trial court jurisdiction, that's original jurisdiction, so they can hold trials. We talked about it as usually trials between states, issues between states, but the vast majority, 98% of the cases that they hear, 99%, is appellate jurisdiction, where they hear decisions that were made at other courts and have moved up, and the Supreme Court is the ultimate authority. Go ahead.
They also have original jurisdiction as well. Ambassadors.
What's that?
Sorry.
Yeah, ambassadors, there's a couple other cases that would originate there, so it's not just between states. There's a couple of different types of cases, but again, they're very rare that they come have trials. This, of course, is a political institution, obviously, simply because they are appointed by, again, judges are supposed to be neutral, objective magistrates, but can you be? And how can you be? So you should listen to the law and apply the law as And so precedent should matter, and you should follow it. But judges vary in terms of how active they are. Some are significantly active and essentially ignore the law sometimes, and other justices all try to follow the letter of the law. But they get to interpret the law, and they get to interpret what the Fourth Amendment means, and they get to use their own opinions in terms of doing that.
And their kids, they'd be better justices. Because they care about people.
All right, the Supreme Court, just a couple other things. It is extraordinary. This is probably our,
It means nothing.
you know, the best, what I mean symbolic is that it really represents the law of the land. This is, justice is not the Chief Justice of the Supreme Court. The Chief Justice, John Roberts, is the Chief Justice of the United States. All right, and so this is where the idea of justice is supposed to take hold in the country. So if you've ever been to DC, you've been to the Supreme Court. The building is awesome. It looks like, you know, it sends a message. And courtrooms tend to be that way. They tend to try to send a message about this is where important things happen. This is where we think about justice. This is where we, you know, give out and decide cases, really important cases. So the symbolic nature. So the reason why the Supreme Court, when they issue a particular decision that's controversial or high profile, right, is that they try to be very careful in terms of how that is presented to the public, because again, it influences. If you've been to DC when there's protests going on, people protest the court decision. Certainly when Dobbs, the decision that overturned Roe versus Wade, it was Roe versus Wade. It was extraordinarily controversial. Protests occurred across the country in terms of turning a 35-year precedent and overturning that. And so there was extraordinary discussion, but the justices were concerned about how the public would consume that and how the public would consume it because of their role in terms of supposed to be representing justice. I really want to let it.
Every time to think it's like he's scoring a goal. Go to FBI.com/apply.
Because of, you only have 9 justices, because they're busy, and because the number of appeals are great. They only will hear a few cases every term. On average, they hear about 100 cases that impact this course in a term, that actually have criminal justice applications. They also have to make decisions about bankruptcy law, you know, family law, administrative law, all types of law, regulatory law, all the different laws, that civil law, all those different types of laws that we really don't spend a lot of time on. And so only a small portion of the cases that they deal with are criminal law cases, but they choose the ones that are most important, the ones that are most impactful and most important, like this case.
Wayne Thompson.
This is Wayne Thompson. Wayne Thompson was in Oklahoma at age of 15. He found out that his sister was being physically abused by her boyfriend. So he and a couple of his friends assaulted him and then murdered him and then tried to destroy the body. Right? So him and his friends were charged with homicide in Oklahoma. Oklahoma is the death penalty state. And so him in particular, because he was sort of the leader in the decision to commit the murder, at 15 years old was charged with homicide, and he was charged as a death eligible case. He was convicted of the homicide, and then he was sentenced to death. What he did then, after he was sentenced to death, put on death row, he appealed his conviction in that it was a violation of the 8th Amendment, protection against cruel and unusual punishment, that we can't actually give somebody who's 15 years old the death penalty. They're not of an age, right? So his case was a juvenile court case that was transferred to adult court, and then he was sentenced to death. So the Supreme Court decided to hear that case, saying it was important enough to decide who should be death eligible based on age. And so Thompson versus Oklahoma, the Supreme Court heard the case, heard arguments about age, whether or not somebody has the capacity at age 55 to understand the right and wrong of their actions, etc., the seriousness of the case. The Supreme Court heard all the facts and decided that we can't execute somebody, we can't put somebody on death row. Made 15-year-olds no longer eligible for the case. That's the only types of cases that it applies to is 15-year-olds and below were not death eligible, right? They left open the question of, can a 16-year-old be charged with death? And a 17, and 18. In the later case, several years later, they heard the case again because they wanted to make it clear that not only are 15-year-olds not eligible for the death penalty, up to 18-year-olds, right? So if you're 18, you commit a homicide, and you do it in the state that has a death penalty statute, you are death eligible, and you could be charged with the death penalty and could end up on death row. If you're 17, 16, 15, 18, all the way down, it's impossible to be charged with death in the United States because of those two Supreme Court decisions that made it 18 as the cutoff age for being death eligible, right? But that was an important enough question for the Supreme Court to issue several rulings on, sort of define the nature of that. Yes, Andrew.
In your opinion, do you think people should be sentenced to death?
You keep asking my opinion, and really, the thing like this, my opinion really shouldn't matter. I have opinions about the death penalty, and we're going to talk about the death penalty, but I want you to make your own opinion about it.
I know. I think it's wrong. I just want to know yours.
When we talk about the death penalty, I'll talk about some of my thoughts about the death penalty at the end of the semester.
Okay. Thank you.
So the very first day.
All right. So let's move down to intermediate appellate courts. Any questions about the Supreme Court?
Go to FBI.gov/apply. I had to write my student ID number and
All
my
right.
name.
So intermediate appellate courts.
Tell them.
First, importantly, they only have appellate jurisdiction. Should be obvious as we talk about who has original, they do not. They only hear cases. So no cases start here. Only cases come here based on a decision from a trial court of general jurisdiction or based on a U.S. district court. So it has to be appealed. So they only hear appeals of decisions that are made by other courts. This is where most cases in both the state and federal system end. All right? Getting the Supreme Court are really difficult. All right? And getting that, the issues are only going to be important. So most appeals never get past this level. They never get past the intermediate appellate court. They usually confirm the decision from the lower court, and then the case moves on. You can keep appealing. You can appeal other issues and try in different ways. But if the intermediate appellate court decides not to hear the case or issues the decision against you, it goes back down, or you can appeal it up if you want. But most cases end in one of these two courts of appeals. There's one Supreme Court, there's 13 U.S. courts of appeals spread out across the country, and so they'll hear cases from the district court, they'll make a decision, and the Supreme Court will ultimately decide to confirm or think about whether or not they hear their particular cases. Just a couple of things about appellate court decision making in terms of variables that influence judges in terms of whether or not they hear an appeal and whether or not they decide in a particular way. What we know and what research tells us, number one, is that ideology matters a great deal. You saw that with the Supreme Court, right? Conservative justices are going to be driven by crime control, like thinking about a particular case. So they look at the law that way, they look at the facts, they apply the facts that way, and thus their ideology matters. And if you are a due process judge, you are going to be citing more, you're going to interpret the law and the facts more along the lines of a more due process oriented approach. We also know that gender matters, right? Female justices tend to side more with the defendant versus the state, all right? They're more compassionate about it. And the other issue that matters is race. That both Black and Hispanic Hispanic judges are much more likely to side with the defendant, much more likely to be due process oriented than crime control in this decision making. So ideology matters, race matters, and gender matters. All right, the last tier that I'm going to talk about is major trial courts. This is where the rest of our time we're going to focus on what happens in major trial courts. And so again, the lowest tier. So trial courts of general jurisdiction are the felony trial courts of state systems, and the U.S. district courts are the trial courts of the federal system. So the processes that we talk about, prosecutors versus defense attorney and justices, hearing issues of legal law, thinking about facts, where state issues happen here, U.S. attorneys versus defense attorneys, judges, federal judges happen at the U.S. district courts. These cases here, now they don't just hear civil cases, criminal cases. They can also hear civil cases as well as other types of cases. All right. All right. One last thing about dual court structure. If you know these facts, you understand the entire dual court structure. So first, state courts are required to honor the Supreme Court's federal constitutional decision, even if you disagree with them. All right? So constitutional issues impact every single court, every single legal decision in the U.S. So the Supreme Court makes a decision, rules in a certain way, the Supreme Court overturns its decision, right? They have to honor it for the next case that they hear. All right? So Supreme Court is the ultimate authority. So state courts are absolutely required to honor the Supreme Court's federal constitutional decision, even if you disagree. So if you don't like Miranda, you're a lower court, right? You know, you still got to follow the rules of Miranda. You still have to follow the Fifth Amendment in terms of, because the Supreme Court said the Fifth Amendment means this. In order to not be able to be punished for self-incriminating yourself, you have to give those warnings. All right? You may disagree with it, you may not like it, but you have to follow the law. What the Supreme Court does, and only does, right, is determine whether the government conduct is consistent with the Constitution. Now, this is where it gets a little bit tricky, but also interesting, because state courts cannot undermine what the Supreme Court did. They cannot undermine federal constitutional safeguards. But all the federal Supreme Court does is set minimal constitutional standards, meaning that they can actually enact statutes that give defendants more rights. And so again, we talked about Miranda versus Arizona, which establishes, according to the Fifth Amendment, the Supreme Court says, yes, you can interrogate somebody, but prior to custodial interrogation, you have to read them their rights. That's the federal constitutional rule. A state could have extended the rights to individuals by saying, all right, you can't interrogate them at all. You can't ask any questions. And that's farther than what the Supreme Court, U.S. Supreme Court required, but it's at least what the Supreme Court required. All right, so it's a minimal constitutional standard. States can go farther than what the federal Constitution requires if they so choose. They can't go lower. So, what a state court can do is rely on the state constitution to extend a criminal defendant's rights beyond what is required by the federal Constitution. And so, if in certain states they don't like what the Supreme Court has done with a particular constitutional right, whether it's our Fourth Amendment, Fifth, Sixth, Eighth Amendment, right? And then what defense attorneys will do is they appeal a conviction on state constitutional grounds rather than on federal constitutional grounds, hoping that a state constitutional judge or group of judges will be more akin to sort of side with the defendant in a particular case. I won't talk a lot about these, but this is where it gets real confusing, so I won't spend a lot of time on a lot of it. But United States versus Leon, remember this is a good faith exception, where if the warrant is wrong, according to the Supreme Court said U.S. versus Leon created a good faith exception. All right, that's the minimal standard. In some states, they have gotten around that Fourth Amendment requirement of a good faith exception by simply more directly specifying what has to be within a warrant in order for it to be constitutional. And if those things don't exist, then the evidence gets thrown out. All right. Any questions so far? Okay. We're going to shift gears. All right, that's the new court structure. That's section 1. We're going to talk a little bit about the courtroom work group now. And then we'll end this section talking about the courtroom process, pretrial trial. And so, again, where we're going now is where these two courts, and mostly the state courts, we're going to be talking about what happens in these particular courts, where a defense attorney represents a client, represents an individual who's charged with crime. A prosecutor who represents the state brings charges against a particular individual. They each present evidence, trying to convince, in most cases, a jury that this person did it or they didn't do it. And then a judge, sort of a neutral arbiter, is supposed to hear the evidence, think about the issues of law, and then make decisions that either strengthen the case or weaken the case. And we'll talk about those issues first. So when we talk about the courtroom work group, there's a lot of individuals in courts that impact what happens in the decision making that occurs. There's clerks, there's tons of other juries, which we'll talk about, and recorders and everything else. But really our primary concern when we think about the courtroom work group is these three groups of people: prosecuting attorneys, defense attorneys, and judges. This is the sort of the lifeblood of decision making that occurs in criminal courts and civil courts.
So they work together. It looks
So I want to talk about each of them. I'm going to start with the defense side of this, right? So the defense, obviously, the defense attorney represents the individual who's in charge, of individuals who's in charge with a particular crime. So let me talk a little bit about their different responsibilities. Obviously, what an individual does is represents the client. This is somebody who has your back, if you will. Somebody who represents you, right? What you're expected to do is cut through the complexity of the court. Legal issues and legal law is quite complex and quite difficult to interpret. And thus, you hire somebody, if you can afford them, you hire somebody to represent you, to help you cut through the complexity, to help you walk through the steps and understand the law and how it applies to you. Most people have misconceptions about what police officers can and can't do. Most people have misconceptions about what the law says and how the law impacts you. Defense attorneys don't have those same misconceptions. Their job is to sort of interpret for you what the law can do and what police officers can do and what they might have done wrong in a particular case. And so it's really important to use attorneys to sort of figure out the legal complexities of a particular case. It's kind of like you know, if you were injured, right? Let's just say you went snowboarding and you had a bad fall, and I don't know, it caused you to lacerate somewhere, right? You got a tree branch, right? Where would you go? Yeah, immediately as fast as possible. Go to the hospital and go to a doctor. Because physicians are extraordinarily paid. Getting through medical school, those of you who want to go, is extraordinarily onerous. Those of you who have family members who are doctors know this. The amount of training that it requires, the amount of sophistication though, and also the time with patients in terms of the training that occurs. So if you have a lacerated kidney, would you want me to do it? I promise you, you would not want me to do it. But you go to a doctor in order to do it because they know the complexity, they've been trained to do it. The same thing with lawyers. They understand the law and they understand the complexities that go into interpreting the law. So what a defense attorney will do is prepare your case. Remember that we start with a police officer making an arrest. They collect evidence based on their lens of what happened. They establish probable cause. They socially construct and tell the story based on to justify their arrest. Your defense attorney does the opposite. They look at it and say what mistakes they made. What other evidence is there that proves that you didn't do it, that helps? So they will interview other witnesses. That's not, the police officer's job is not to make you look innocent, right? The police officer is going to do their job in terms of establishing probable cause. Your defense attorney is going to prepare your case. And so they're going to make questions about any scientific evidence that's presented. They're going to question every single witness that's put on the stand, as well as any types of other evidence that's presented by the prosecuting attorney. That's their job. And so this helps. So what a defense attorney does is first they look at the evidence of the case. And they look at it and think about it in terms of what's the likelihood of conviction? What is your risk of going to trial? They question the police officer's tactics. How did they get the evidence? How did they get the physical evidence? Did they question you? Did they interrogate you? And what they did in that interrogation. They look at, those are all legal issues that are appellate issues that they're trying to think about. They're looking for gaps, problems with the case. They're looking at the strength of the case. And so what they'll do is once they look at your case, they look at the facts, they'll get the police report, right? They'll get all the scientific evidence reports. They'll get any videos that the prosecution looked at. They'll talk to witnesses. They'll put all of that on the table, and they'll analyze it, and then they'll talk to you about your case. And they're going to say, the prosecution's got a really strong case. Got to be honest with you. Or the prosecution has a really weak case. Or the prosecution has a case with some holes. All right? And that's when they start talking about what are your options. You know, what makes most sense in your particular case. Should we go to trial? Should we take a plea bargain? How bad should we push? What should we spend time doing? What can help in this particular case? And so you talk about those and you collaborate about what works in a particular case. And then the defense attorney's role is to do what you want them to do, right? Even if it's against what they recommend, right? The defense attorney might say, look, the prosecution's got an incredibly strong case. We should take a plea bargain. It's pretty fair. You're going to spend some time in prison, but it's not going to be a long time, right? If we go to trial and you lose, it's going to be a long time. It's a really strong case. But despite that, right, if you want to go to trial, the defense attorney's job is to do the best that he or she can in representing you and making sure that you don't end up in prison at the end of the day.
So no matter what, the defense attorney must listen to the defendant's wishes, right?
Yes.
Okay, thank you.
Yep. They have to follow what the defendant wants. They'll ask, and if it, at trial, the judge will say, are you doing this on your own accord? Is this what you want to do? So if you plead guilty, right, one of the things you have to do is allocate and actually say what happened. So you go before a judge and say, I did this and these sorts of things. Are you doing this of free will? Are you doing this, without any pressure? So defense attorneys may pressure, but ultimately they have to follow what a defendant wants, even if they shouldn't do what they actually want. It's not in their best interest. But it's their life that, they're dealing with. All right, so who gets an attorney? How do you get an attorney? How do you use an attorney? So we got to talk about the right to counsel. This is probably one of the most interesting areas of law and important areas of law. For everything we talk about this semester is on the right to counsel and who has the right to an attorney. So we got to start with the important. So remember, evidence in general and the collection of evidence deals with the Fourth Amendment and Fourth Amendment issues. Incrimination, double jeopardy, that's all Fifth Amendment related case law. Here, when we talk about right to counsel, there's various different parts of the Sixth Amendment, but importantly for us, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. We'll talk about what that is. But also, at the very end of the Sixth Amendment, it says, and have the right to the assistance of counsel for your defense. Right? You have, all of us, have a Sixth Amendment right to be represented by a counsel. The unfortunate thing is that for most of U.S. history, that meant is that you have the right to an attorney only if you can afford an attorney for yourself and pay for one. So that takes us to some case law. These are really important cases that you should know. You should talk about your friends with. They're extraordinary cases. The first is a 1932 case, Powell versus Alabama. This is the famous Scottsboro Boys case. Movies have been written about it. A lot of people, really interesting books have been written about it. The facts, the short version of the facts that what occurred in this particular case. These 9 African American gentlemen boarded a train in Alabama, and while on the train, there was a altercation that occurred. There were 6 white males and 2 white females in the same car. There was an altercation that occurred between 2 groups of individuals. There was a fight that broke out. All right. Punches were thrown. People were pushed around. At the next stop, the train stopped. The white males and the 2 females got off of the train. The 9 African American youth stayed on. Right? They got off the train. They went directly to the police. Police said they were assaulted. The 2 women said they were raped. At the next stop, the police were there. All 9 of the individuals were arrested and charged with sexual assault and Alabama. They appeared before the judge. Just said they were not represented by counsel. Right? They did not have an attorney. They said, we need an attorney. We don't know what's going on. They weren't. They were all convicted in a 1-day trial in groups of 3 and sentenced to long periods of incarceration. Right? So, this case now starts here, right? They were arrested in Alabama, charged with sexual assault in Alabama, right? They represented themselves. Didn't do a very good job of representing themselves. They were all found guilty. A 13-year-old was let off. Charge was diverted out of the case. So 8 out of the 9 were sentenced to long periods of incarceration. They were convicted here and sentenced to long periods of incarceration. Go to prison. As they're here, though, they appeal their conviction, right? It's actually a legal group appeals their conviction. They start through the state system. They go to intermediate appellate courts. Their convictions upheld. They don't have the right. The issue that they're raising is they said that we needed an attorney. The Sixth Amendment requires that we get an attorney. Intermediate appellate court said no. State Supreme Court said no. Eventually, the U.S. Supreme Court heard the case of Powell versus Alabama. And in that case, the Supreme Court said this. it acknowledges the complexity of the legal system. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with a crime, he is incapable generally of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise admissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he has a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. Look, it is complex. I studied the law and been part of the law. I'm not a lawyer though, right? And if I was ever charged with a crime, the first thing I would do is hire the best attorney that I could. Right? I would understand maybe some of the flaws in the police procedure. If I've ever interacted with police, I understand some of that, but I could not defend myself, and I wouldn't think about defending anybody else because I have no legal training. That's not my job. So what the Supreme Court said here is the law is extraordinarily complex. We need at least in some certification that your client signed. You signed with your client. The Supreme Court did in 1932 was said that if you can establish special circumstances, you have the right to law office without having to go to law school. That is the rule. That is the Sixth Amendment rule in 1932. And so what the Supreme Court said is because the individuals who were arrested and put in prison were young, and they were also charged with a very serious crime. They were charged with homicide. They created a special circumstance. So then the Supreme Court said in the Sixth Amendment you have the right to an attorney in 1932. That is if you can prove special circumstances.
Go to FBI.gov/apply.
Questions about Scottsboro, Powell versus Alabama? In 1938, Supreme Court hears the Sixth Amendment case, Johnson versus Burke. Right, this is a federal case. It started in federal court. U.S. District Court is charged against federal law. Right, didn't have an attorney, couldn't afford an attorney, couldn't pay for it, defended himself, lost, was convicted. Appealed his conviction in the federal system from the U.S. District Court, the intermediate appellate courts, lost their his conviction was upheld, and then went to the United States Supreme Court. All right, the Supreme Court said in 1938 that if you are charged with a crime in federal court and you cannot afford an attorney, you get an attorney. Attorney must be provided to you by the federal government. All right. The important thing to write down about Johnson versus Zerk is that it was a federal case only. So what that Johnson versus Zerk only applies to is federal cases. So in 1938, you're charged, you're arrested by the FBI, say, I can't afford an attorney, I need one, you have to be arrested. You're charged by the state of Michigan, the Michigan State Police, you don't have the right to an attorney in 1938. Because it was a case that the facts only dealt with a federal case, it only applied to federal cases. So in 1938 until today, if you don't have it, you can't afford an attorney, you have to be provided one. Inexplicably, almost, 4 years later, Betts versus Brady was an opportunity to apply that same rule to states, and whether or not states had the responsibility to provide attorneys and can't provide it. Right? Now, it would make sense legally, right? That if in federal cases somebody has to be provided counsel in all particular cases, you would expect them to extend the right to state cases. Again, inexplicably, they said no. That they reaffirmed the special circumstances case for state cases. So they reaffirmed Powell versus Alabama and Betts versus Frey, which makes no legal sense for a lot of different reasons. So, in 1943 United States, right, if you're arrested and charged with federal code violations, you can't afford an attorney, the federal government had to provide you an attorney. In 1943 United States, you're arrested by a state police officer, Ohio State Police, and say, I can't afford an attorney, I need an attorney. If it doesn't imply special circumstances, like age, like the seriousness of the crime, you don't have the right to an attorney. Two different, depending on where you start, two absolutely different sets of laws until 1963. Gideon versus Clinton. This is Clarence Earl Gideon. This is from the Supreme Court. They actually have an ad to Gideon. They have a display on the Gideon decision. Gideon versus Wainwright.
Some t-shirts too.
So Gideon was in Florida. He was at a pool hall, and he robbed the pool hall. Stole money from the pool hall. He was charged with felony and was brought to a trial court of general jurisdiction. He goes before the judge. He doesn't have his own attorney. Says, Judge, I have no idea what I'm doing. I'd like an attorney. Can you give me an attorney? The judge in Florida in 1961, when he was arrested, said, look, you don't have the right to an attorney in this state. You have a special circumstances rule. When you've been charged with a serious crime, but it's not serious enough, we don't give an attorney for you in your circumstances. You have to defend yourself. 8th grade education, tries to defend himself in court. Not surprisingly, he is convicted of a crime. He is sentenced to prison. He goes to prison, and with the help of inmate lawyers and other legal groups, he appeals from prison his conviction, saying that the Sixth Amendment requires that I should have an attorney because I am not able to defend myself. And in 1963, the Supreme Court threw out the special circumstances rule and decided in Gideon's favor, right? They said that reason and reflection require us to recognize that in our system, our adversary system of criminal justice, any person that is hailed into court who is too hard to hire their own attorney can't be assured a fair trial unless counsel is provided. This seems to be an obvious truth. Governments, state and federal, quite properly spend vast sums of money for dollars to establish try defendants accused of crime.
Discriminated against
Lawyers
because
and
they're poor.
prosecutors are everywhere deemed
The other
essential to
gonna
protect the
cover
public
it.
interest in the organized society. Similarly, there are few defendants charged with a crime. Few indeed who fail to hire the best lawyers they can get to prepare and present their defenses. Right? If you have the money to spend whatever you got in order to hire the best defense attorney, when O.J. Simpson was charged with murdering his wife, he spent literally millions and millions of dollars. He hired a jury, he hired a psychic, he hired a jury expert, he hired multiple attorneys because he had the money in order to do it. And you would because you're hoping that it gives you an advantage, right? That's what the court is saying, that it's too complex for us as members of the public to defend ourselves. So you either hire your own attorney, and if you can't afford an attorney, which has to be established in court, in this particular Gideon is requiring Sixth Amendment means you get an attorney. This completely changed how criminal justice works in criminal justice. What it said in 1963, according to the Sixth Amendment, that any person and every person who can't afford an attorney has to be provided to one, has to be provided an attorney. This is incredibly important about the Gideon decision. Because he was charged with a felony, again, it only applied to state felony cases. So in 1963 or 64, if you were charged with a misdemeanor, it was an open case whether or not you get an attorney. But because of Gideon, every single person has to be provided an attorney, which meant that every state has to decide now, how do we provide somebody an attorney when they can't afford one? Because the vast majority of who end up in the criminal justice system actually need some assistance, do not have the money to pay for their own attorney. So let me talk about one last case. Again, it took the Supreme Court 9 years to decide what happens in misdemeanor cases. And the question is, if you're charged with a misdemeanor in courts, do you have the right to an attorney? Again, this is according to the Sixth Amendment, you do if there's a possibility, if you're convicted, you have a possibility of being in prison, which is a lot of misdemeanors, but not all. So if you're charged with a misdemeanor where the maximum punishment is a $10,000 fine, no possibility of imprisonment, you don't have the right to an attorney in the United States. But for any crime, misdemeanor or felony, where there's a possibility of prison, you have the right to attorney according to the Sixth Amendment. Questions about any of the case law? There's two special circumstances cases, Powell and Betts, both at the state level. The critical thing to remember about Johnson versus Lewis is it gives federal defendants only the right to counsel if they can't afford one. Gideon gives only state felony defendants the right to counsel if you cannot afford one. And then Argensinger extends it to misdemeanor plus when there's a possibility of imprisonment. So, in 1963, again, every state in the country then has to decide, what do we do, how do we provide counsel? We'll talk about that. There are various models that states use. Obviously, private is just paid for the defense. You can see ads all over. There's attorneys all over the place. You can pay for an attorney anywhere from $100 to $500 an hour to hire an attorney, depending on their going rate, and it varies depending on the individual. So a private attorney is they represent you. You pay them some fee. They charge you an hourly wage, and then they walk you through the system. They show up at court with you. They handle interactions with the prosecution. They look at the evidence. They do all the things for a case, and you pay them in order to do it. Now, if you can't afford that, right, you show up before a judge and you've been arrested and say, look, I can't afford my own attorney, all right? The judge establishes that you can't afford your own attorney. Then depending on what state you're at, what county you're in, it's determined about how that attorney is going to be given to you, all right? So a lot of counties use public defenders. A public defender is a government employee. Government employee who has been hired, and their full-time job is to represent clients and people who have been charged with crime who cannot afford it, right? And so you have lawyers, you have investigators all in the public defender's office, and they represent the people who have been charged with crime. That's their full-time job. It's the only types of cases. And so you're a full-time public defender. You're a state employee, just like a prosecutor is. Do you have a question? Yeah, it's a great question, right? Yeah. So the question is, how do you determine whether or not somebody is, the critical thing is whether or not they're indigent, whether or not that's been established. And so they will ask for financial records if there's any doubt. Sometimes they accept it as fact for a variety of different reasons, but oftentimes they'll say, you have to prove it. You have to prove, give us your financial statements, and they'll look at tax statements, they'll look at where you're working, whether or not you're currently working, they'll look at bank statements as well, whether or not you own a home, all those sorts of things. It varies by jurisdiction, but they'll have to make a determination that you can't afford to do it. All right? So public defender, that's a full-time job. So if you're represented by a public defender, they only hear public defense cases. They're a state employee, they're applied by the state. So the way this works is, right, you don't have to worry about, nothing comes out of your pocket. They represent you, they're paid by the state pays the county to have a public defender's office. The other model that many states use is something we call assigned counsel, okay? So again, if you don't want a public defender agency with full-time employees, right, what they do is they sort of put it out to all the attorneys that practice in the county. And they say, all right, you're a private attorney, you have your own practice, somebody may call you and you can represent them. but you can also be put on a list of attorneys that we will assign if you want cases that are represented by the state. Meaning, that is, if I appear in a county with assigned counsel, and I say I can't afford an attorney, the judge will essentially go down the list of assigned counsel in that county, and then pick one of them, and then they will assign my case to that individual. And then that individual, who now represents me, right, will bill the state, and will be paid by the state. And so the state will pay for that time, for those cases, right, for representing. So the assigned counsel has both private clients, and they also have public defense clients. In some states, like the state of Washington, for example, has a law firm with hundreds and hundreds of attorneys that are hired rather than public defense that are hired to represent every single case, all MDG cases in that particular county, particular place. All right, questions about any of those different models? Just remember that a public defender is a full-time employee and only does public defense cases. Assigned counsels do both private and public defense, contract only public defense, but also other types of contracts. Go ahead. That's a great question. In states, yes. So in the same state, the fees are set by the legislature, right? Same thing with assigned counsel fees. In the same state, they all get paid the same, right? They vary by state though. And so different states will have different fee rates. All right, we'll talk about the other side of this on Thursday. We'll start talking about stocks. Have a good day.
Let me ask you a quick question. Put FBI in that session.